Once again, I want to thank everybody for joining us today. My name is Mark Krause. I'm an associate attorney in the estate planning department with Copenbarger and Copenbarger. And the topic for today is going to be yours, mine, and ours, estate planning for blended families and remarriage. Here's a little legal coverage that we have here, a little disclaimer, like, all the side effects messages at the end of the drug commercials. I do need to note that this information is provided for educational purposes only, so this should not be considered legal advice. In case you want to bring some sort of legal action against me later, this is provided for educational purposes only. If I was going to give you actual legal advice, I would need to sit down and drill down on the specifics of your unique situation to make sure I'm giving you proper advice and that my advice is tailored to you. But there's a great way we can do that, namely by attending this webinar. You can get a free appointment with me afterwards, so please ask us about that, and then I can give you actual legal advice. This is just a snapshot of our attorneys with the firm at Copenbarger and Copenbarger. Unlike some firms in the estate planning space, we are not just a one-man operation, although Lloyd, our founder, is extremely influential and his sort of DNA runs throughout the firm. He did not set up a one-man operation. We have multiple attorneys across multiple different departments, including the estate planning department, business tax and advanced planning department, estate administration department, and hopefully never have to end up here, but the litigation department. So we have multiple attorneys across multiple departments to meet, whatever legal needs that you might have. This is a snapshot of our wonderful staff that helps us as attorneys look great every day and, just helps us out in innumerable ways. We have multiple locations all across California to meet your needs, all the way up from, Santa Cruz all the way down to San Diego and, many, many places in between. And of course, we can also meet with you via Zoom or even a phone call if necessary. So we can basically be where you need us to be. So what are we going to be talking about today? This is a list of the topics up there: family dynamics, estate planning, roles and responsibilities, protection strategies, planning gaps, and plan maintenance. So first, family dynamics. Family dynamics do create unique needs. Yours, mine, and ours complexity. Different relationships affect decisions. So yours, mine, and ours can really be a twofold thing. It's not just about property, where yours, mine, and ours, particularly if we have a marriage where one or both of us, it's not our first marriage, we might bring property that's yours, mine, and ours. I might have a house that's not yours. You might have a house that's not mine. We might have all sorts of bank accounts that are separate property beginning the marriage, but once we enter into a marriage, then we start to develop an ours. We start to develop community property assets, but this isn't just true of assets. And there, believe me, there's plenty of complexity that I'm sure if you're on your second marriage or you're part of a sort of blended family situation, you probably are already familiar with how important community property and separate property and that distinction is for anybody that's gone through a divorce. But there's not only yours, mine, and ours property, there's yours, mine, and ours potentially children. So we might have each brought children into a new marriage, and then we might have our own children in the marriage that is ours children. And all these things bring just kind of a heightened degree of complexity and require a lot of intentionality for planning purposes. Perceived parenthood versus equality. Every household is different. This, I'm sure it's a struggle for every blended family to figure out how exactly, especially if we have yours, mine, and ours kids, to treat those kids. We want to be fair, but obviously, one thing I've learned, I'm not in a blended marriage, but one thing I've learned just having 3 children, one size fits all is never the case with kids. You might love all your kids equally, but they're all different. So it can be very difficult to balance perceived fairness versus genuine, sort of equality, treating them equally versus, all these considerations. It's never one size fits all situation to try to do the right thing by your kids. Spouses and children have interests that may differ from each other, may not align. You might bring adult children. You might have adult children that are not the same as your spouse's adult children and vice versa. And they can have very, very different interests that you need to consider when you're doing planning. Value of sentimental property. A lot of times, and this is something I'll come back to throughout this talk, people miss how important the little things of non-monetary value, but of sentimental value, how many issues that can cause. It can be really important to think about those things when you're doing planning, because a lot of times the worst litigation can get set off from the least valuable things from a monetary standpoint. Maybe a piece of costume jewelry that two daughters thought was really important. You might never have guessed it because maybe the jewelry is not worth much, but you have a great degree of sentimental value, and a fight over that can lead to litigation that, lasts years and goes into the six figures. So it's something that you really want to be attentive to. Goals must reflect real relationships and often really should kind of mirror the reality of the family. You might want to just do a simple one size fits all and treat all the kids equally, but that might not really, you know, account for the reality of the relationships. Again, there's no one size fits all. We really have to be attentive to the actual people and interests and the actual family dynamics. Grief, something again that I'll touch on again, grief can really strain relationships. And if we don't have a carefully thought out plan in place ahead of time, the heightened grief can really exacerbate any already existing tensions, any perceived unfairness, and any other issues. The grief will really, really heighten those issues and potentially bring them to a boiling over point. Multiple households increase complexity. This is especially true, it's true, like I said, for property, for kids' inheritance rights, and both, whether or not something's community property versus separate property is going to affect things. Whether or not a child is yours, mine, or ours obviously affects things in terms of inheritance rights. One thing, again, that I'll probably touch on again, with regards to kids, you might think that maybe your stepchildren have inheritance rights. One thing you should be aware of is, in general, unless you've actually legally adopted them, generally speaking, they're not going to be considered your children for the purpose of any inheritance rights. There's a lot of factors and moving parts that we need to be attentive to there. Emotional dynamics can influence your decisions, especially decisions of like, who do you want handling your stuff, as your sort of backup trustee, for instance, or your executor after you pass away. Maybe there's a couple kids that grew up together and get along. Maybe there's one child that's, was an adult when you got married and has almost no relationship with the other kids. You need to think about how those factors might, go into play. Maybe it's a good idea to have an outsider child, be in charge of everybody else's inheritance and administering their estate. Or maybe that's a terrible idea because that's going to exacerbate existing tensions. You need to really think about that. Clear intentions guide planning outcomes. You really need to think out, and again, I'm going to keep harping on this. It's going to be really hard to have a plan that works effectively if you don't even know what the plan's supposed to do. You need to really think ahead of time what we're trying to accomplish with each aspect of your estate plan. And you need to be clear on what you're trying to accomplish first. And then, theoretically, you should be working with an attorney like me to, once you have a clear intention that you can express, to figure out how to actually effectuate that the best. But if you haven't thought out a clear intention ahead of time, it's really difficult to make sure that the plan actually accomplishes those intentions. Structure helps manage expectations. A really defined plan will set up, the proper boundaries. It'll make sure things go in the right places. It'll make sure that the right people are in charge, and it'll avoid, any ambiguity or confusion about where things are supposed to go, about who's in charge, about who makes these decisions. You really don't want to leave any of that in an ambiguous situation because, like I said, grief will heighten the tensions. And if there's anything to fight about that's ambiguous or seems like it's up for grabs, people will fight about it, potentially, believe me. Teams should collaborate well. I generally am not going to recommend co-trustees or more than one person in any particular decision-making position. But if you do that, the first thing I ask whenever anybody talks to me about what about appointing co-executors, co-trustees, that sort of thing, is I say, do they work really well together and do they have an absolutely fabulous relationship? If the answer is, not really, don't even think about it. Don't even think about appointing two people to do something together with regards to your estate plan if they already don't get along, because they won't get along when they're arguing about important things, believe me. So take an inventory. Marriage increases planning complexity. Like I've said, legal rights change after remarriage. While before there was just, your property. Once you get married, there, like I said, there becomes an ours potentially. From the moment you get married, as you may already know, any, for instance, one thing, uh, any earnings that you earn during your marriage from the moment you get married become community property. So what a lot of times people don't really appreciate the complexity of, say, having a separate property house. You might think that you've brought a separate property house into this marriage and that if something happens to the marriage, that's just going to stay your separate property. Well, not necessarily true. If there's a mortgage on that property and you just keep paying it with, even if you're paying it just with your own wages, not with your spouse's wages, once those wages are wages that you're earning during your marriage with that new spouse, the community is now essentially buying a proportional interest in that house simply by you paying down principal with wages that are now community property. So that's one thing in general that you need to be really attentive to, is the complexities of what's separate, what's community property, and are we changing anything right by that? Doing different things with title can affect whether or not, if you're buying a new house together, you have to be really attentive how you're taking title about whether or not this is community property versus separate property. Inheritance rights are going to potentially change. You might have thought before, oh, I'm getting married, so my kids are obviously going to inherit all my stuff, even if I haven't done any estate planning. But if you haven't done any estate planning and you get married, that spouse becomes a new predominant factor in terms of your inheritance, unless you have something planned to the contrary in a will or a trust. So you really need to be attentive to how legal rights change once you get remarried. Automatic inheritance rights, like I said, spouse is going to get automatic inheritance rights unless you do something about it via estate planning once you get remarried. State law is going to control regardless of how you feel about it, even if you and the spouse have a bunch of thoughts about it. If you haven't done any actual legally binding estate planning, whatever state law says, that's what's going to control. One thing we always tell people is that even if you don't think you have a will or a trust, you actually do have a will. It's what has been laid out by the California State Legislature and the California Probate Code. So the state legislature has written a plan of inheritance for you. They've decided all the inheritance rights for your loved ones. And if you don't put your own plan in place, that's going to be the default and that's going to control. Planning is important even if you do not have any children, even if there's no yours, mine, and ours with regards to kids, even if it's just another marriage where neither one of you have any kids. Planning is still important unless you just want to default to the spouse getting everything. That might not be what you want, though. You might have siblings, parents, nieces and nephews, charities, all sorts of things that you might also want to give to rather than just 100% going to the new spouse. So that's something that you really need to be intentional about, again, unless you want to just accept the state legislature's will that they've drafted for you. Like I said, provisions can protect children's inheritances. If you actually are intentional about these things and you do your own estate planning, you can make sure that you're actually protecting your kids' rights when you get into a new marriage. So if you want to make sure that your kids are getting the lion's share of everything, because maybe when you get remarried, you're both perfectly established in that second marriage. Maybe all your kids are full grown and you're really not marrying this person for any sort of financial reasons. You're just marrying them, to have companionship, and you still want to keep your financial life at least somewhat separate. You really need to be attentive to do your own planning to make sure that those kids are protected. You may effectuate an accidental disinheritance. This is something to really worry about. So if you die in general, let's say you have multiple children, if you're like me, let's say you have 3 children and your intent, maybe you've been a single parent for a long time and you're getting remarried you might have intended for everything to go to your kids. And if you would have passed away as a single person, your whole estate would be split equally between your 3 kids. But the second you get remarried, now that spouse, if it goes to, the state created will, that spouse has tremendous rights. Number one, they're going to get anything that's community property, which is one reason you want to make sure it's very clear what's community property and what's not. But the second, any community property created, pursuant to that new marriage, is going to go 100% to that spouse if we're following the state's will, the will that the state has planned for you. And any separate property, you might think, well, that's fine for community property, but surely my separate property is safe. Not so. That separate property, if you have multiple children, is going to go 1/3 to the new spouse, 2/3 to your children. And if you only have one child, that's, any separate property you have is going to go 1/2 to your spouse and one half to your child. So that's something you really need to be attentive to and decide whether or not you're willing to accept the default will the state's drafted for you, or whether or not you need to do your own planning. So you could accidentally, disinherit children. But also, there might be a case where, God forbid, you have to intentionally disinherit some kids. That's obviously going to require specific planning. That's not something that'll just happen by default. If there's a situation where, for one reason or another, say an addiction issue or something else where you need to actually disinherit a child, you need to actually do some sort of bespoke specific planning. So estate planning, that's kind of what we're leading to, talking about all the things that could go wrong if you don't do any estate planning. Now we're going to talk about estate planning. Advanced Healthcare Directive is one of the tools in our estate planning arsenal. Essentially, an advanced healthcare directive, which is something everybody, I should say, over the age of 18 should have. You might think, for instance, that the child that at 17, you could go in and have automatic rights to know what's going on with them and to make medical decisions with them. You might think that still applies once they turn 18. It does not. The second your child turns 18, they become a full-fledged adult in the eyes of the law, and you have no automatic exemption from HIPAA, which is legislation, if you don't know, that essentially protects patient confidentiality and the confidentiality of patient information. So once you're 18, you need an advanced healthcare directive, and the healthcare directive will basically sort of do three things. The first thing it'll do is it will give somebody an exemption from HIPAA so they can find out what's going on with you. The second thing it'll do is empower that person to make medical decisions for you when you need them to. And the third thing is it'll lay out certain wishes in advance that same person responsible under the healthcare directive will be responsible for seeing it carried out. Things like what happens to your body after you die. Maybe you want to be cremated, maybe you want to be buried, maybe you want something really interesting. That's something that all goes in the healthcare directive. Sometimes healthcare directive gets confused with a durable power of attorney, because sometimes we like to call a healthcare directive a healthcare power of attorney. So not to confuse the two, the durable power of attorney I'm talking about is a financial power of attorney. Essentially appoint somebody to be able to step into your shoes, sign things legally on your behalf, and most importantly, manage financial assets on your behalf. Again, this is something that you as a parent do not have an automatic right to manage your child's finances or sign legal documents for them once they hit the age of 18. They become a full-fledged adult, and you can't just substitute your will for theirs anymore. You need to have formal legal documents in place. So this is, again, something that might be a good idea sometimes for people. Say when your child graduates high school, a nice graduation present might be getting them a healthcare directive and a durable power of attorney, so that now that they're a full-fledged adult, if something ever happens to them and they're incapacitated for any length of time, you can make sure that there's something in place so that you can take care of them. The alternative to having a healthcare directive and a durable power of attorney, the sort of court alternative, is a conservatorship. If somebody becomes incapacitated and they do not have these documents in place, then the only way someone gets to make as long as they're an adult, the only way somebody gets to make medical decisions or financial decisions for them is essentially if you petition the court to get a conservatorship over them. And if you've never been involved with a conservatorship, I can tell you it is very difficult, expensive, and time-consuming. And it's, as long as the conservatorship's around, court involvement is never really totally over until that person passes away. And even after they pass away, you essentially have to get court approval, get the court to co-sign on everything you did before you can really close that out and have that part of your life be over with the court. So if you don't want to get tied up in a conservatorship, you need to make sure that there's an advanced healthcare directive and a durable power of attorney in place. Next thing is probably the most common document people think of when they think of estate planning is a will. A will control what happens to your assets in a probate situation. And it can also allow, you can, through a will, appoint an executor, which is the person that would be in charge of carrying out the wishes in the will. However, this still has to go through probate court. That's the major disadvantage of a will in California, is it can get you out of the situation where you're solely relying on the sort of state-created default will in the probate code, but a will still have to potentially be administered through probate court. So your executor might have to go through the entire probate process. It's just that you will have set the rules as to who's the executor and what happens to your stuff ahead of time. Another important thing that is usually found in a will is a nomination of guardian. So something to be very attentive to if you have minor children and you're a parent. and something if you have maybe adult children with their own minor children that they need to be attentive to, is who would raise the children if both biological parents passed away. You might think that there's some sort of default thing in place about who gets to raise your children. You might even think, as you know, the next sort of bullet point talks about a godparent. You might think that because you've appointed a godparent, that gives them some sort of legal rights to raise your children if both you and the other biological parent pass away. Not so. It may be important in the eyes of the church and in the eyes of God, but in the eyes of the law, a godparent status in church really isn't anything. They're not going to look at the baptismal certificate. Doesn't mean anything to them. If you want something legally binding that can actually influence and have an effect on who gets to raise your kids, if both you and the other biological parent pass away, then you need to have a nomination of guardian. It's a formal document where you nominate who the guardians would be if both you and the other biological parent pass away. Usually it's found in conjunction with a will. So if you don't have a will and you've never done a will, you basically have not contributed, or you don't get a say in who raises your kids if both you and the other biological parent pass away. So that is definitely a reason, if you've never thought about that, to think about it and then schedule an appointment with me so we can get that figured out for you. Trust and supporting documents. Trusts, this is essentially my favorite estate planning document. After a will, it's probably the next most commonly well-known estate planning document. Major advantage of a trust in California is that a trust can do similar things to a will in terms of deciding who's going to be the person responsible for carrying out your wishes after you die and for setting all those wishes in place as to what happens with your stuff after you die. But a trust can be fully administered outside of any court involvement. A trust does not need to go through probate court. The only time a trust is going to wind up in probate court typically is if somebody initiates litigation. So other than that, a trust can be fully administered outside of any court involvement, which will save tons and tons of time in terms of how long the court process takes. Best case scenario in California, you're going to be looking at if you're having to go through an actual probate, you're going to be looking at least a year and a half if everything goes very smoothly. If things go less smoothly, it's going to take longer. I can tell you I was in probate court very recently in Orange County, and this was kind of in mid-April, and the earliest continuances the judge was giving out in probate matters were for like mid-October. We're talking about hearings taking place in mid-April. Next available hearing, if you had to clear anything up with a petition or whatever you're trying to do, was in October. So just keep that in mind and think about how many hearings you might need to go through to get through a full probate. You can stack those on top of each other and realize it could take quite a long time to get through a probate. Plus, probate is very, very expensive. A typical trust administration is going to be a fraction of what a probate administration is going to cost. So these are both very strong reasons to have a trust rather than just leave it up to the probate court. Plus, once a judge in probate court is essentially an emperor in their own, universe, and there's not a lot of ways to really get around what they say. What they say is the law, is the law. The only way you can get around that is by appealing their decisions if it is actually a final decision. And appeals are extremely expensive, again, extremely time consuming, and almost all of them lose. So essentially, when you're giving everything up to the probate court, you're putting a lot in the judge's hands. What they say is the law is essentially the law. So trust can support your long-term planning goals. We can do a lot of things in a trust to structure things to tailor it to the specific needs of your family, and especially if you have a blended family, your unique situation. Multiple kinds of trusts. So there's some acronyms here. You might say, what's a SPAT? That's a little bit of our nomenclature that we use internally. An SPAT, as we call it, is a single probate avoidance trust. JPAT is a joint probate avoidance trust. An AB trust and ABC trusts add a little bit more complexity, which oftentimes can be important in a blended family situation. The really important thing to note about an AB trust, the way it works is when the first spouse passes away, it limits the ability of the surviving spouse to make changes to the trust. And the way that it does that is when the first spouse passes away, the trust subdivides into two subtrusts, one for the deceased spouse and one for the surviving spouse. Those trusts are funded by half the community property and any separate property, allocated to the respective spouses. And for the deceased spouse, their sort of subtrust, their decedent's trust becomes what we call irrevocable. That means basically the provisions are locked up. And if the surviving spouse wants to make any changes, they can only do it with their separate property and their half of the community property, only with their sort of subtrust, their survivor's trust. That's the only thing in an AB trust after the first spouse dies that they can make changes to. So if you are trying to connect the dots, that can be really, really important. If you have a blended family situation, one of the basic things that can help do is make sure that if that surviving spouse, if you're the first spouse to pass away, it can make sure that the surviving spouse can't write out your kids from the trust. They might get remarried and decide that they want to redirect where their stuff goes away from your kids if they don't share those kids, and they might want to give stuff to a new spouse or even new stepkids. You can at least lock down your half of the community property and your separate property by doing an AB trust, so that if they want to change where the stuff goes, they can only do it as so far as affects their half of the community property and their separate property. So you can make sure that at least your half of the stuff and your separate property is there to protect your kids and that it can't be redirected. So that's a very important thing that an AB trust can do in this kind of a situation. An AB trust also, and even an ABC trust can also do this. It can help if you are facing any estate tax issues. Everyone who lives in California should know there is, surprisingly enough, no California estate tax. That means your estate doesn't have to pay any tax to the state of California, merely to transfer your assets after you die. There is a federal estate tax, but that federal estate tax the threshold is very high right now. It's currently set at about $15 million. So if your estate falls below that $15 million mark, you're basically not going to have to worry about any estate tax issues. But if you do have to worry about it, let's say your estate's worth $20 million, AB provisions or ABC provisions will potentially allow you to get more than $15 million. So an AB trust, basically what that allows you to do is you can take the whole exemption at the death of the first spouse, and then the whole exemption a second time at the death of the second spouse. So instead of merely being able to clear $15 million tax-free, you can potentially clear double that. Maybe your estate's worth $29 million. You can take that full 15 million at the first death and the full 15 million at the second death. And that way you can avoid paying any estate taxes at all with an AB trust. And an ABC trust just gives you even more flexibility, basically, to try to avoid estate taxes. All these kinds of trusts, though, can be used for married couples. The only sort of caveat with the sort of single person or the single probate avoidance trust is if we did do that, and we're talking about a married couple, we would be doing two separate trusts, one for one spouse, one for the other spouse. It's not the most common thing. We don't usually do that in California, but for states that are not community property states, which California is a community property state, that is actually very commonly what people have to do is do two single trusts essentially for each spouse. But which trust is right for you, again, is going to depend on the specifics of your situation, and it's something that you should talk through with an attorney before making the decision about what kind of trust is right for you. Trust and supporting documents. So GSTs, that stands for generation skipping trust provisions. You might ask, well, what in the heck is that? And why would I be interested as in a generation skipping trust provision? So originally, these provisions were primarily designed for basically rich people to defer the payment of estate taxes. And they called it generation skipping because it essentially allowed them to defer the payment of estate taxes for a whole generation down to the grandchildren level. The way that it does that is instead of, say your kids simply receiving their inheritance, in the simple, straightforward way, you give them their inheritance within a trust that's set up for that child's whole lifetime. And their inheritance essentially will stay in that trust throughout their lifetime, and it won't leave that trust until after they die and things go down to the grandchildren level. And only then will the assets be actually outside of a trust, and then the government gets to tax, any estate taxes due at that level. Because we're in a situation now where we have that high $15 million threshold, most people don't need generation skipping trust provisions for that purpose anymore. So the main reason we tend to use them now is for the protective aspect that they can offer. And the way that works is because the trust that you would be leaving your kids' inheritance in to them, the trust you would have set up to give them their inheritance in, essentially is its own. The trust is irrevocable, And so that essentially means that it's its own legal entity, kind of like a corporation. So by leaving them their inheritance in that, if your child's name John Smith, you would leave them their inheritance in the John Smith, lifetime trust. And that lifetime trust, because essentially it's a separate legal person with a separate tax ID, kind of like a corporation, it'll shield the inheritance from pretty much any legal liability that John Smith could get himself in. So let's say John Smith, God forbid, gets a divorce himself. Anything in that lifetime trust will be protected from the divorce court. The divorce court won't be able to have any jurisdiction over it, won't be able to get at it, because John Smith can look at the court with a straight face, say, hey, I don't own any of that stuff. That whole inheritance my parents set up for me, that's property of the John Smith Lifetime Trust. Its own separate legal person, own separate tax ID number. That's not mine. What you can do also is you can set up that same child as the trustee of that lifetime trust, which essentially will mean they can do anything they want, including they could spend everything, out of that trust if they wanted to, but so they'll be totally in charge of it. But as long as they have something in that lifetime trust, it'll protect their inheritance from all sorts of legal liability, whether it's divorce, lawsuit, bankruptcy, all these sorts of things. It'll protect their inheritance as long as they keep something in that lifetime trust. So this can be a pretty powerful tool for protecting your kids' inheritance and making sure that even if they get into all sorts of legal trouble, sometimes I describe it like a Job-like, referring to the biblical book of Job, a Job-like set of calamities. Let's say their business fails, they're getting sued throughout, in connection with their business. They have to declare bankruptcy, their spouse leaves them, they're going through all this stuff. Maybe they lose all the assets that they've accumulated throughout their life as a result of all this calamity. But if you've given them their inheritance in this sort of lifetime protective trust, this generation skipping trust, then they can at least have that to fall back on, because that'll be protected from all these sorts of legal issues that they could get themselves into. So I'm sure you can see that it can be a very, very effective and important tool to consider using in your estate planning. Flexibility of joint versus separate trusts. So obviously, if both spouses have separate trusts, then that is going to give you a lot more flexibility in general in terms of what you do with things. They'll essentially be distributed, entirely separate. The trust will just be entirely separate universes that don't have to make any reference to each other. If you have a joint trust, you're going to have to put, one person essentially, or the same, if you have co-trustees, which I don't recommend, the same trustee or co-trustees are going to be in charge of any joint trust. If you have totally separate trusts, you can say, hey, look, in a yours, mine, and ours kids situation, you can say, my son is in charge of my trust. My son is the backup trustee. So when I die, he's the one that'll be taking care of things. And you, with your kids, you can make your son or your daughter in charge of your trust. And they don't really have to interact with each other at all. If you have a joint trust, then you're going to have to potentially pick and say, well, my son's the backup trustee for both of us. Or sometimes I've seen this situation, it can work, but it's not advisable. Sometimes people say, well, to ensure fairness, I want, my child, who's not your child, to be one trustee, and you can have your child, who's not my child, be a co-trustee. And that'll theoretically, ensure fairness or ensure that both sides are sort of represented. Often that's a bad idea, because any disagreement between co-trustees can lead to gridlock and even worse, litigation. But that is something that people can do sometimes. But if you have a joint trust, there's a lot less flexibility in the sense of you have to have the same people that are in charge of the trust. If you have two separate trusts, you can kind of have separate universes, and there's some more flexibility in terms of distributing assets that you can do with a separate trust as well. Memorandum, letter of instruction. This is not exactly a legally formal document, legally binding document, but this is just a really good idea to have in general with your trust. You can create a letter of instruction that can give the kids, or whoever your backup trustees, because another thing to consider is if there's a yours, mine, and ours situation with the kids, maybe picking any of the kids is a bad idea, because it'll just create issues. Maybe you need to find some other party, like an aunt or an uncle or a friend, or maybe there's just no person that's right for the job, and you might even need to consider appointing a professional fiduciary, somebody that does this sort of thing for a living, to be a neutral third party. Those are, depending on your situation, all things to consider. A letter of instructions is something you can put in for your trustee. that is really versatile. It can provide all sorts of information that you want people to know about when you pass away. Anything from contact info for all the people that you want contacted after you pass away to, information about safe deposit boxes. If you have stuff that you're keeping in safes in various places and you're like, how in the world would they ever figure out where this stuff is? You can put that in a letter of instruction and keep it with your trust. So that, or even give it to people outside of, your actual physical trust, because it could be the case also that you need a letter of instruction to explain where the trust is. You can include how you want, you can identify all sorts of digital assets, say, this is where I've got my crypto. This is where all the family photos are kept on the cloud. This is the password for how you access all that stuff. And the letter of instruction can also work with, so when I say memorandum, our trust provides for the possibility of creating a written memorandum that can be legally binding. And the purpose of that memorandum is to provide specific wishes as it regards to the distribution of tangible personal property. So tangible personal property just means not real property, not houses, personal property that you can touch, basically. So clothing, jewelry, art, memorabilia, all sorts of tchotchkes, furniture, all these sorts of things. You can prepare a written memorandum according to the terms of the trust that we prepare that can provide for specific gifts of that kind of stuff. So a specific plan for, it can be really important, especially for sentimental items. If you're worried that, two kids might fight about this asset that maybe isn't really worth very much, but maybe this, family photo album or this, painting of the family that somebody did has a lot of sentimental value. You can specifically earmark that in a memorandum. That memorandum, at least if you have the trust that we draft, if you prepare it, will be legally incorporated into the terms of the trust by reference. So that memorandum actually can be legally binding. And you can kind of do that in conjunction with a letter of instruction or even as like part of the letter of instruction. But understand that the only part of that really be legally binding is that memorandum directing gifts of tangible personal property. And that's only if the trust specifically, like our trust, allows for it. Within the confines of the trust. If the trust doesn't make any reference to that kind of a memorandum and you prepare one, it's not necessarily going to be legally binding. Roles and responsibilities. We've already kind of touched on some of this, but this is very, very important. You need the right person for the job. And a lot of factors can go into whether or not the right person is in the right job. So what are the roles, that we might be talking about in an estate plan? An incapacity panel. This is somewhat unique to our trust. There are some trusts that have this kind of provision and some trusts, a lot of trusts that don't. This specifically has to do with so something that you should know if you create a trust, you will be the settler of the trust, the creator of the trust. Sometimes we can also call this a trustor or a grantor, even a trust maker. I've seen all those terms used. We prefer the term settler. So you will be both the settler, the creator of the trust, and typically, unless you provide differently, you will also be the trustee, who's the person in charge of managing the trust assets. So that a trust is essentially like a contract you create with yourself. You say, hey, self, you seem like a trustworthy fella. I'd like to put you in charge as basically the CEO of managing all my stuff. So here you go, self, you're now the trustee of all my stuff. You're the one I've entrusted with decision-making power and management power over all my assets. So every trust will have a provision that lays out how exactly someone could be removed as trustee if they're no longer competent. And obviously people can get brain injuries, they can develop, psychosis issues, they can have dementia, Alzheimer's issues. All these things can lead to incapacity, which disqualifies them for being a trustee. And the way our trust works, the way that our provision, reads typically is that it's going to require one doctor's opinion. So the person will have to be evaluated by a doctor, but then that doctor's opinion saying that they're no longer capable of acting as trustee and making financial decisions, that in order to be effective, that doctor's opinion has to be ratified by something that we call a competency determiner. And that competency determiner can be either one person. Typically, if you are married and you do a joint trust, the other spouse will be the first competency determiner. But if you're either not married or if you're doing a separate trust and you don't want to put your spouse on there, you can pick basically whoever you want to be your competency determiners. And like this part of the slide suggests, it can be a panel. It doesn't have to be just one person. Let's say you're like me and you have 3 kids. Obviously, right now, my kids are, well, hopefully it's obvious that I don't look like my kids are all adults now. If it does look like that to you, please don't put that in the comments. We'll keep that to ourselves. But I have 3 young children ranging from 8 to 2.5. So maybe when they're adults, I might want all of them to act together as my competency determiner. I can either appoint all 3 of them to act by majority vote or even by unanimous vote. And that kind of acts as a check on the doctor's opinion to make sure that I'm not being declared incapacitated willy-nilly just from maybe that doctor had a weird day or was kind of a goofball of a doctor. Having competency determiners in place helps make sure that there's people that actually know you well, that can sort of act as another layer of decision making to act as a check against that doctor's opinion. So both things have to happen, doctor's opinion and competency determiners ratifying that opinion in order for it to take effect and remove you as trustee. So that's basically what an incapacity panel is. And a lot of times, if we're having a yours, mine, and ours situation with regards to the kids in a marriage, especially if it's not a yours, mine, and ours, if it's just a yours and mine and we don't have the same kids, really common to have different competency determiner panels set up. If you have 2 kids from your previous marriage and I have 3 kids from my previous marriage, it doesn't have to be this way. It can be any way you want it. But a lot of the times it's very common to have my kids acting as my backup competency determiners and your kids acting as your backup competency determiners. Godparent or legal guardian. Again, godparent is a term that is, I'm actually a godparent to multiple children, believe it or not. And I have godparents for my children. Godparent is really important, maybe in the eyes of your church. It is not a legally recognized status. So however your kid's baptism certificate or confirmation certificate or whatever way in which your godparent status is memorialized, it is not going to be legally binding in the eyes of the law in any way. So what we need is to appoint, if you want that godparent to be a legal guardian, you need to actually appoint them in a nomination of guardian to be a legal guardian. That's the only way that you're going to be able to it's the only way you're going to be able to exercise any influence on who gets to raise your kids if both you and the other biological parent pass away. So do you want it to be a couple or an individual? If you're already attentive to the fact that people can get divorced sometimes, the difference between appointing a couple and appointing an individual can be really important. Even if that individual is married to somebody else, if they're on their 3rd marriage and you don't really know that spouse very well, you might not really want to appoint the couple as the guardian. You might just want to appoint one person. Or if, this couple or your best friends and they've been married for 20 years and they have a very stable marriage, you might want to appoint the couple. And then if, one of them passes away or something happens, you want the other person to do it. But that, again, is going to depend very heavily on the specifics of the situation. And it's something that you need to factor in when you're making a decision about how to set up guardian provisions. Trustee executor. Executor is the person in charge of a will. Trustee is the person in charge of a trust. If you have both a trust and a will, we're always going to have that be the same person to avoid any conflicts of interest. But you really want to make sure that your backup trustee is going to be, the right person for the right job. Make sure it's somebody that's going to be financially literate. It's going to be responsible, going to be fair, going to be able to work well with, all the beneficiaries of your trust, which, again, the trustee is the person in charge of carrying out the terms of the trust. Beneficiaries are the parties that have a beneficial interest in the trust. So typically speaking, you're going to be the only beneficiary of your trust while you're alive, but after you pass away, your kids and or anybody else that you name as a beneficiary, then they're going to be the beneficiaries of the trust. You want to make sure that the trustee is the right person, both by temperament and by competency, to take care of the beneficiaries and ensure that your wishes are carried out. Guardian of the estate and guardians of the person. So this is an important thing for that legal guardianship. There's 2 different kinds of guardianship. Guardianship of the estate is going to be somebody that's in charge of the kids' finances and controlling their finances. Guardian of the person is basically going to be in charge of all the miscellaneous other stuff, like where they live, healthcare decisions, where they go to school, all that kind of stuff. Usually we don't make a distinction between guardian of the state and guardian of the person. Usually you're just going to give one person or one couple guardianship over your kids if both you and the other parent pass away. But your situation again, is unique to you, and you might want to separate those, spheres of authority out in some way. That's something to think about, as we have a conversation about it. Technically separate spheres, guardian of the estate versus guardian of the person. Usually they're combined, but they don't have to be. We've already touched on what a beneficiary is. A co-trustee is just a trustee acting with another trustee. So if there are two trustees, two people responsible for the trust at any one time at the same time, they will both be co-trustees, just meaning more than one trustee having authority at the same time. And the successor trustee, that's a trustee that has not yet been appointed, but is named as a backup if something happens to the person in front of them. So you might have a successor trustee list that's five. I mean, kind of a lot, but maybe it's 5 people long. They're all potentially successor trustees, but they're not actually going to be a trustee, not an actually appointed trustee, until the person in line ahead of them can't do it and they have to step in. Clear definitions. I've kind of touched on this, but clear definitions is always clarity, clarity, clarity. Very, very important. You don't want any ambiguity in what happens to your stuff and who's in charge of it after you die. Trustee is there to manage assets, like I said, for the beneficiaries. There are fiduciary duties that apply. If you open up the California probate code that I referred to earlier, there's a big, long laundry list of fiduciary duties that they owe to the beneficiaries. A lot of them are pretty common sense, but there's a long list of them. Things like follow the terms of the trust, don't engage in self-dealing, don't treat different beneficiaries unequally, be prepared upon a reasonable request to share information and possibly accounting relevant to that beneficiary's share in the trust. All these things are fiduciary duties that the trustee is going to be responsible for. If they do not properly carry out their fiduciary duties, they can get in legal hot water very quickly. So if one of those beneficiaries notice that they've violated the duty to avoid self-dealing, maybe the way a trustee can do that is maybe they're supposed to sell a piece of real property as part of their duties carrying out the terms of the trust and eventually get all that money to the beneficiaries. Let's say they sell the house to themselves personally for hundreds of thousands of dollars below market value. That's what we would call self-dealing. Not allowed to do that. If a trustee does something like that, the beneficiaries, or if the beneficiaries are minors, they're legal guardians. And this would be like a guardian of the estate situation. If it's not the same as the trustee, can potentially bring a lawsuit, remove that trustee, and hold them accountable from a financial standpoint for all the value or dollars that they diverted away from the trust. So trustees have fiduciary duties that are very important, and if they don't fill them out properly, if they don't carry them out properly, they can be held legally liable and have significant consequences. Roles selected by skill versus fairness. Really common issue. You might just think, hey, obviously the fair thing is I'm just going to make my oldest child the trustee. That's fair, right? Make the oldest child. Well, what happens if they're not the right person for the job? Maybe in your, mindset, being the firstborn naturally means they should have that responsibility. But if there's somebody that's had to file bankruptcy 5 times, not somebody you want to be your trustee, right? You need somebody that is actually going to be financially literate, financially responsible, and has the right temperament to deal with the other beneficiaries if they're complaining or if they have an issue. You want the right person for the job. Fairness should not really factor into it when you're deciding who the person in charge of your trust is going to be. You might consider fairness more in the sense of who the beneficiaries are, how the property is going to be carved up. But when you're making a decision about who's in charge of administering your trust, who the trustee is, the successor trustee, don't worry about fairness. Worry about right person for the job. Clear duties and expectations support smooth. Well, and I should say, just circling back on that, another way that can manifest that situation, you might think it's fair to do what I mentioned earlier in a yours and ours situation where my kids are my kids and your kids are your kids, and we have, a second marriage. You might think it's fair to appoint one child from each side and have them be co-trustees. That sounds kind of balanced, right? Probably a bad idea. I would almost always say don't do that. Co-trustees are almost always a bad idea. If there's any possibility for friction, fighting, and disagreement, you essentially should not appoint them as co-trustees. One trustee is almost always, without exception, the best. And whoever the trustee is, even if you do appoint co-trustees, you need to pick the right person for the job. Don't worry about as much about hurting feelings or about what people perceive as fair. Worry about picking the person that's going to be able to do the job fairly, properly, competently. So clear duties and expectations support smoother administration. Trustees will follow your written directions. That they legally have to follow all the directions that are in the trust. And hopefully, if you lay out external directions about other miscellaneous things, like in a letter of instructions that aren't covered by the trust, that won't necessarily be binding unless it's what we're talking about, that memorandum for tangible personal property. That, if your trust says it's binding, will be binding, but other stuff in a letter of instruction may not be binding. But there might be, like I said, really, really clear instructions about how you want them to handle certain things. They're in a letter of instruction. Make sure that you pick the right person that's actually going to follow your instructions, and make sure those instructions are as clear as possible. And I wouldn't wait until your backup trustee's dead for them to find out, or until you're dead for your backup trustee to find out that they're the backup trustee. I would have a conversation with that person while you're still alive to make sure that they have some idea of what to expect. The more they understand what their job is ahead of time, the better chance that they're going to be able to do the job properly. If they're only finding all this stuff out for the first time, that they suddenly have been appointed with this huge responsibility when they're going through grief at your death, that's not ideal. It's a lot better of an idea to let them know ahead of time before your death so that they can prepare themselves and so they can take a look and think about those duties and try to understand them when they're not, having a full-blown, grief meltdown because of your death. Authority prevents administrative confusion. Maybe all four kids, if let's say you have one kid from each marriage and two kids that are both yours in a blended family situation, and they all think that they get an equal vote. That's, like I said with co-trustees, a bad idea. Having one person in authority means that there's no ambiguity in how things are going to get decided. Everybody else can pipe up if they want to, but clearly delineating who has authority and who doesn't means that you're going to be able to have decisive action taking. It's clear who has the authority to make decisions, and when they make a decision, it's clear that that's legally binding, and that's what we all have to deal with. So clear positions of authority and the right person for the job will avoid lots and lots of fighting, intractable disagreements, strife, and hopefully avoid any litigation. And delays, my goodness. If you're waiting for everybody to get on the same page before we decide what's going to happen in a trust administration, you almost might as well go to probate court and, have your estate take 2 years or 3 years to administer. We don't want to wait until everybody's on the same page if there's multiple parties involved. Pick one person in charge that has authority, and they will decide what the answer is. They don't have to poll everybody before making a decision. Reducing misunderstandings. So, like I said, define roles, limit disputes. If we know who's in charge of each thing, then we're not going to be able to hold up those decisions. One person will just get to make those decisions. This is important not just for your trustee, but also your healthcare directive. Maybe different people have different thoughts about whether or not you should be put into a care facility if you've got Alzheimer's, what that facility would look like, how much money should be spent on that facility. Maybe they have different opinions on whether or not you should be removed from life support. We need clear positions of authority where the buck stops with somebody. We don't want to wait until all your kids and stepkids and whoever else agrees on things. We want somebody with actual defined authority and a defined role with the right person for the right job to be making a clear decision that's legally binding. That's going to avoid a lot of issues. Just have a person in a clearly defined position of authority and make sure it's the right person for the right job. Structure protects family relationships. It can really, when all that stuff is set out, and again, you might want to communicate some of these things ahead of time, not just to the person who will be the backup trustee, but it's often a good idea to communicate that with everybody, even if it might ruffle some feathers. If you've got, 6 kids and some of them are only your spouses, some of them are only yours, and some of them are both of yours, even if it's going to ruffle some feathers, if say, only a child that's only yours is going to be the only backup trustee, or maybe one of both of yours is going to be the backup trustee, or the other spouse. Even if it's going to ruffle a lot of feathers, I would advise you ahead of time, not just to tell the person who's actually going to be the backup trustee, but I would communicate that with all the interested parties. Even if they get their feathers ruffled, giving them time when they're not under the stress of grief to come to terms with that decision is going to go a long way typically towards mitigating, the bite, the pain of that, and it'll go typically a long way to avoiding the possibility of litigation. It's not always the case because there's no one size fits all guarantees to everything, but very commonly I'll tell people just tell all the kids ahead of time, all the beneficiaries ahead of time, who's going to be in charge and where everything's going. Because even if they don't like it, it's a lot better to find out, 5, 10 years before you're dead than to suddenly be surprised by it when they're in the throes of grief and when all their emotions are completely out of whack and heightened. There's a much better chance that they'll make their peace with it if they've known for 10 years what everything's going to be than if they suddenly get surprised and think that that surprise is unfair, upon your death. So really good idea in general. There could be exceptions to that, and I can help you talk those through and see if that's advisable in your situation. But typically, I would advise making sure everybody knows is on the same page ahead of time. Establish a plan. Planning reduces trustee conflicts. Planning reduces all sorts of conflicts. If you want your wishes to be carried out in a clear, coherent manner, make sure that you have a plan in place. The only way we can make sure that what you want to happen is going to happen and that the right people are in charge is if you actually do formal estate planning. So please, please, if you haven't done any already, please schedule a free consultation with me. We can talk through it and make sure that you have an actual well thought out plan in place that reflects your actual intentions that you've spent time thinking about. Protection strategies to protect your goals, to carry out your goals. Balancing clarity and fairness. Like I said, clarity reduces family conflict. Clearly defined roles and clear instructions about what properties going where, about who gets what share in the estate. All those things, the more clarity, the better the chance that conflict will be avoided. Another good example of clarity helping reduce conflict. You may or may not be aware that Prop 19 went into effect a few years back in 2021. Prop 19 drastically reduces the applicability of something called the parent-to-child exclusion. That's an exclusion from having the house reassessed when there's in terms of property taxes, when there's a transfer in ownership. It used to be the case that any house or any piece of real property that a parent transferred to a child qualified for the parent-to-child exclusion, meaning that the child would be able to submit an exclusion, request with the assessor's office and get to keep paying the same property taxes as the parent was paying. After Prop 19, that is no longer true. The only kind of transaction that qualifies, the only transfer that qualifies, parent's primary residence, and child's taking it as their primary residence. So an example where clarity reduces family conflict, something we often do is a right of first refusal. Maybe you want to put them in the best position possible for one child or another specifically to take the house so they can qualify for that exclusion and keep that property tax basis. You don't want to just in general say, any kid who wants it gets an equal bite at the apple. That is a recipe for fighting and litigation. If you put in a right of first refusal, you can say child A gets the first bite at the apple only if they don't want it. Child B gets the second bite at the apple, so on and so forth. By clearly laying that out, you can avoid lots and lots of conflict by defining everybody's legal rights very carefully ahead of time. Fairness considers diverse needs. So circumstances amongst different people are not identical, especially in yours, mine, and our situation. It could be the case that the kids that are just ours, one thing you should know about them is they don't have some other, parent out there that's going to be providing for them. It's just you and your spouse, if that's just your children. If you have a child with somebody else, maybe that other person has a whole lot of money and you already know that they've set up a trust in place where they're going to leave that kid more money than they ever know what to do with. So maybe it's not really the right thing to do to give equal shares to that child that's already being provided for elsewhere and a child that is solely depending on you and your current spouse. Um, you know, uh, it's not a one size fits all. So you really have to, maybe one of your children has disabilities, and you know that they're going to need a lot of money to take care of them for the rest of their life, but you have some other child or stepchild that, is a Fulbright scholar that is going to be pulling in, a very high six-figure salary for the rest of their life, and they don't need the same thing. So you need to not just think about fairness one-dimensionally in terms of everybody gets an equal share. You should think about it as what's going to be the best thing to do to take care of each person as an individual. And you really should think about it across multiple sort of dimensions, not just unidimensionally. Planning can support long-term harmony, preserve relationships, do everything you can to avoid your family, especially if it's a blended family, devolving into acrimonious fighting and litigation that can last for years. You can balance all sorts of different interests between kids that are mine, yours, ours, kids with disabilities, kids with better financial outlooks, different challenges. Kids are going to be receiving an inheritance from somewhere else. You can address all sorts of these competing priorities and really tailor a plan to your unique circumstances that's going to do the best job possible of accomplishing your specific goals. Again, guardians for minors must be legally documented. If you have children that are minors and you do not have a nomination of guardian, you absolutely need to at least do a will and put that in place. Please schedule a time to talk to me about that. Written plans guide court decisions. That guardianship it's not automatically going to be followed by the court, but unless there's a really good reason, typically, such as the guardian saying they don't want to do it, typically speaking, that's going to put them in a position where they're almost certainly going to get appointed, as long as the court doesn't see some sort of really, really major red flag with that guardian. Informal choices don't have any authority. Like I said, the court is not going to just recognize the fact that you've appointed somebody as a godparent in the eyes of the church. You telling somebody or promising, or maybe a whole web of people know about it ahead of time what your wishes are. If you haven't put that in a nomination of guardian, none of those things are going to be legally binding. And you really need to put stuff in place to protect the minor children because you want to be able to be intentional and plan out what's going to happen if you and the other parent die in an untimely fashion. Distribution. Another thing I should say is you can separate some of these spheres of authority between guardians and trustees. So you can pick, you might want it to be the case that this particular person or couple raises the kids, but you don't want to give them full control over that child's money. So like I said, in the distinction between guardianship of the estate and guardian of the person, you can separate those out, or you can separate the sort of financial role out a little bit, just in terms of having money for the kids held in trust for them until they reach, a certain age. And you can appoint a trustee who's in charge of the money. That's somebody different than the guardian. That can help act as a check to make sure that the trustee is another added check on the guardians to make sure they're using the money properly, because they'll have to ask the trustee whenever they want to use money for the kids. Distribution designs for joint separate trusts. We can tailor these things in a lot of different ways. You can have something go, in terms of your separate property as of the death of the first spouse, and have something else go out, only after the death of the second spouse. You can have all sorts of bespoke things, that some things that only apply to your separate property, different provisions applying to the community property, different provisions applying to the spouse's separate property, all sorts of things that we can do to narrowly tailor it to your particular situation. Separate trustee and guardian for minors, I just touched on. Backups for healthcare and financial decisions. A lot of times you don't want to just put one person. You might want to put a backup, after them, to make sure if something happens to them, that there's someone else in place that can take over. And again, make sure that those backups are the best person possible for that job. You might have a need for special needs trusts, which can be either within a trust or a standalone trust. If you ever discuss this with me in detail, in the future, if you have these needs, my preference is to do a standalone special needs trust. But special needs trusts are specifically designed if you have a beneficiary that's collecting government benefits due to a disability, like Social Security disability. It's designed to set money aside for them, but keep it in a trust so that it can be used in a way that doesn't interfere with their current level of benefits, and B, make sure that the money you've set aside is not subject to the government trying to claw it back after that beneficiary passes away. Planning gaps. causes for confusion. So outdated plans, if you've got a trust that you've done in 1989 and you haven't looked at it since then, there's probably going to be some gaps that you haven't covered, some issues, and those issues can cause all sorts of unforeseen problems. And it can cause ambiguity. Let's say that you prepared a trust a long time ago and your family dynamics have drastically changed because, like, I mean, let's say that you've been a single parent for a long time, you have your own trust, and then, you know, 20 years after that, you get married and you never change your trust. That can create really important legal issues and ambiguities that you really need to iron out. So if you haven't looked at your trust a long time, or if you haven't looked at your trust after a divorce or a remarriage, absolutely we need to look at that trust and make sure that it's up to date and taking into account of the current family dynamics in your current situation. Incomplete documents, if you haven't spelled everything out, the ambiguity you've left over can lead to fighting and decisions that the court needs to clear up. Unclear language, I've seen people decide to do their own bespoke little personalized amendments rather than using an attorney, where they'll just write up their own amendment. That language has a high likelihood that it's going to be unclear, in which case, again, when there's a lack of clarity and people are fighting about it, usually the judge has to be the referee to decide what it really means. So unclear language, big problem. Assumptions replace written guidance. Whatever, even if you have an understanding with everybody, you know, with your kids, your spouse, everybody else about what's supposed to happen, what you put in an estate plan, in a written estate plan, is going to legally control. You need to make sure that if you have an intention that you want to see accomplished, that it's actually in a legally enforceable document. Otherwise, it's not legally enforceable. No administration at first passing. I'll try to hit on some of these quickly because I know that we've gone a little long on some of this. No administration at first passing. This has to do with AB trusts or ABC trusts. Very important that when the first spouse dies, you actually set up and fund those subtrusts. As I mentioned before, an AB trust is meant to be split into two sort of subtrusts, a decedent's trust and a survivor's trust after the death of the first spouse. If you fail to do that administration, fail to actually allocate those things, the problem will reassert itself at some point. Someone will have to figure this out at some point, and the longer you wait, if you wait, and which I've seen plenty of times, where you wait and you never do it, and then at the death of the second spouse, you leave a big mess for everybody to figure out. Your trustee is going to have problems that'll probably end up in court if you have not done that administration at the death of the first spouse. And you can see why, because let's just imagine this situation. The trustee A, the trustee that dies first, they want to leave more money to their kids. And then trustee B, the surviving trustee, they want to leave more money to their kids. And so though there are different provisions, in those two, subtrusts between the decedents and the survivor's trust, or let's say it's the same when they pass away, but later the surviving spouse decides, you know what, I've had a falling out with his kids. I'm just going to totally write them out of my portion of the trust. Then it becomes really important what should have gone in each trust. And if there's no clear record of how they got funded back when the first spouse died, it's really hard to recreate that, potentially 10 years later when the second spouse dies. And so that's almost certainly going to land in litigation. So very important that if you have an AB trust or an ABC trust, that we actually do the administrative work after the death of the first spouse. Disinheritance after first passing, this ties into, what we're talking about with no administration done at first passing. If you disinherit one of the kids in your survivor's trust, that often is going to cause some issues. Or even if you don't have a survivor's trust, if it's just a non-AB trust, disinheritances after the first spouse dies can often cause issues. Co-trustees not getting along, I kind of touched on that. It's why in general you don't want co-trustees. No clear plan for the personal property. Like I said, if there's something of important sentimental value that more than one kid is going to want, you want to spell that out in a memorandum. If you don't, there's a good chance they might fight about it later. And like I've said, often those fights can turn into six-figure multi-year litigation. Even if you have a hard time anticipating that, it absolutely can and does happen. Inheritance, separate property being commingled. You don't want to commingle if things are supposed to be separate between the A trust and the B trust. Do not commingle them. If you are the surviving spouse, you have a fiduciary duty to keep the property in those two trusts separate and not commingle those things. Naming guardians with the surviving parents could potentially cause an issue. You should understand that in general, even if you have a nomination of guardian, if that child has still another surviving biological parent, maybe that you're not married to, your nomination of guardian is not necessarily going to control, and in fact, not necessarily, it's almost never going to control over that person being the surviving biological parent. They'll get guardianship over the child, regardless of who you nominate. The nomination of guardian is of primary importance when both biological parents have passed away. There are some exceptions to that, but pretty much that's the case. Uh, Legal guardianship versus godparent, again, it needs to be legally spelled out in an enforceable legal document, not just a baptismal certificate. Guidance for unequal distributions, make sure that if the kids are getting unequal things, that it's very clearly spelled out and you have a clear person with authority to make that happen. And waiting too long to start the discussion. Biggest problem with estate planning, you wait too long, and I've literally had people come to me when they're on death's door, unfortunately. I had a fella not too long ago who came to me when he was very, very ill and was in his 80s, had I think, $7 million or so estate, had never done any estate planning. He also had not paid his taxes in about 10 years, which is going to be a huge issue that we were going to try to clear up for him while he was still alive. He died a couple days after our initial appointment, so we weren't able to get anything signed and in place for him. And it became a huge mess in probate court for it ended up being, I believe, his nephew to clear up for him. Don't wait too long to start the discussion. Consequences are basically the family falling apart, litigation, bitter, acrimonious splits in the family between your kids or your kids and your stepkids that, can basically estrange them forever. I've seen a lack of proper planning tear families apart. It can be really, really difficult. If you've never experienced it, you probably know somebody that's experienced it. So it's really important to do careful planning that is uniquely tailored to your family dynamics, to put your family in the best position to grieve you properly, to receive your property in the best way possible, and to be able to carry on your legacy without tearing each other apart. Plan maintenance. Make sure, just in general, that you're keeping things current. If your life circumstances have changed, we need to make sure your plan reflects that. If you've been divorced, we absolutely need to revisit, any estate planning that you've done, prior to the divorce. If you've been remarried, we absolutely, or even especially, good idea to talk to me about it maybe before the remarriage. If you know you're going to get remarried, you need to make sure that your assets that are supposed to be in the trust are actually in the trust and that everything is titled properly. That means maybe reviewing property tax statements, reviewing the deeds, reviewing account statements to make sure anything that's supposed to be in the trust is in the trust. Make sure the beneficiaries on any beneficiary designated accounts are who you want them to be. Regular reviews are going to reduce your risk of having things be outdated or having assets not be set up how they're supposed to be set up. We usually recommend at least every 3 to 5 years, come and meet with me or, somebody else at the firm, meet with an attorney to look through things and make sure everything's set up the way it's supposed to be. Critical documents to update, you need to make sure that your deeds are to houses and properties are all where they're supposed to be, particularly if they're supposed to be in a trust. That could also mean, though, that the deeds also need to carefully reflect whether or not you want that asset to be community property or separate property. That's going to be controlled by what's in the deed typically. So definitely make sure those are correct. Make sure your beneficiary designations are set up correctly and that if something changed, that they're updated. Make sure the trust is properly funded and make sure that there's consistency between all your assets and all your estate planning documents. You don't want to update your trust to reflect a certain, distribution strategy and then have your IRAs and your 401ks and all your and life insurance policies that are beneficiary designated reflect completely different estate planning goals. You don't want to do that. You make sure that everything works together cohesively. And the best way to do that, of course, is to meet with an attorney to go over these things specifically in a way that takes into account your unique situations. I really appreciate everybody I know I went a little long today. I appreciate everybody that stayed with us for this. I really appreciate your time and attention. So in conclusion, how can we help? We can help you come up with a coherent plan. We can help you clarify your intentions and what you want and make sure that your plan is set up to best carry out those intentions. Personal one-on-one discussions about this are the best way to do it. not getting a one-size-fits-all document off the internet, not just following what somebody else does. The best thing to do is to have a personal interaction with an attorney that can hear you, get to know you, and really figure out what your goals are, help you clarify those goals, and help you put those goals into legally enforceable documents. Why would you work with Copenbarger? We've been around since 1979. We have, I think, over 12 full-time attorneys. We're in the process of hiring right now, plus one attorney of counsel. Over 250 years of combined experience. Some of us have things like advanced tax degrees. Some of us are certified specialists in various areas. Highly qualified, large support staff. Multiple offices, as I mentioned before, all across California to take care of your needs, and obviously the ability to do things over Zoom and remotely as well. So we're not a big problem in this space is attorneys that are one-man operations. If something happens to them, that can really, make it difficult to, continue to keep your estate plan updated. It means you sometimes have to kind of almost start over. We didn't just get open yesterday. We're not going anywhere anytime soon. And we have a large, staff and sort of roster of attorneys that's going to make sure that we're here for you when you need us. Lloyd has set up this firm to be something that endures, well past him. So I think that we're really uniquely placed to meet clients' needs for the long term rather than just being here for a day. So what to do now? Please, this webinar qualifies you for a free estate planning consultation. Normally those consultations cost money, but by just letting us know that you went to this webinar, you get a free consultation either with me or one of the other attorneys. You just reach out to us and we'll get you scheduled to do that and at least have our initial consultation. Please also, please fill out the digital evaluation. You'll see on this slide that there's a link that's referenced to do, and I believe the link is also put up in the chat. So please click on that link when this is over, and please fill out that questionnaire, that evaluation. Please also give me really good scores, but honestly, be as honest as possible because we do really take your feedback into account. It's really important for us. It's how we know whether or not we're serving our clients the best way that we can is by reviewing their feedback, and we try to tailor things in light of that feedback. So I promise you, if you leave us your feedback, we will carefully go over it, and it definitely can have a big impact on how these webinars and our seminars will be set up moving forward. So with that, I really thank you for all your time and attention. I'm going to start looking at questions if you stayed with me. So I'm going to open up the Q&A. Even if you haven't already put a question in the Q&A, if you want to do so now, I'm going to just try to hit everything that we've got set up there. And once I'm done with the Q&A, I will go ahead and see if there's anything in the chat as well. So right now, I've got a question from an anonymous attendee that says, so just choose one. So I am not I think that's probably, if I had to guess, referring to who the backup trustee is or who decision makers might be, like in other things like the healthcare directive and things like that. In general, yes, I mean, there is no one size fits all advice that is perfect for everybody, but in probably 99% or more of situations, I will advise you to just pick one person to be in charge. When there's more than one person in charge, there can be conflicts, disagreements, and it A, can lead to litigation, and B, it can just lead to gridlock where decisions that need to be made aren't made, especially if those decisions need to be made in a timely fashion, which typically they do. So your situation is your situation. If we meet together to prepare your estate plan, you will be the boss, and I'll put into place, within reason and legality what you want. But in general, my advice is going to be for any position of authority, with the exception of competency determiner. With that one exception, my general advice is going to be just choose one person. So what is the difference? This is a question we have. What is the difference between a revocable and an irrevocable trust? To revoke something means to take it back. So in general, a revocable trust means you can take it back, and an irrevocable trust means you can't take it back. And the rules for revoking a trust are basically the same in general, the procedures for amending a trust. So the main idea between a revocable trust is it's something you can make amendments, you can make changes to during your lifetime. And if you want to, you can even just revoke the whole thing, just cancel out the whole thing during your lifetime. An irrevocable trust, you cannot just take back very easily. You typically, in order to be able to revoke an irrevocable trust, you need to specifically get a court order to do that. And it's often very difficult to do that. They're not going to do it for just any reason. So an irrevocable trust, for the most part, is going to be not possible to revoke. And for the most part, not possible to change. Sometimes, depending on how the irrevocable trust is drafted, there can be certain, we don't call them, abilities to amend the trust. We might call it a power of appointment that gives you a little bit of wiggle room to change certain things. But in general, an irrevocable trust is going to be more difficult or impossible to amend or revoke during your lifetime. That's why usually we use the word living in conjunction with a revocable trust, a revocable living trust, because generally what we mean by that is this trust is around for your lifetime, and while you're alive, it can be changed in any way and even revoked by you. So that's basically the difference between a revocable and irrevocable trust. I'm going to take a look at questions if there are any in the chat as well. So let me see here. Okay, that's just kind of a thanks. So I will say thank you very much for the feedback. I really appreciate that. I will give just a second for anybody else that wants to ask any questions. If you have any questions about anything I talked about today or anything sort of vaguely tangentially related to the area of estate planning and trusts, I am here, for just another moment to answer your questions. If you stayed with me this long, I really, really appreciate your time and attention. And again, if you haven't already done so, please go ahead and fill out that digital evaluation link. Click on that link and give us your feedback. I promise you, we carefully review it, and we do tailor what we do in the future to your feedback, because we want to be here for you and meet your needs. And the only way we perfectly know what those needs are largely is if you tell us. So please give us your feedback. See. Okay. All right. It doesn't appear as if there's any more questions. So with that, again, I really, really thank you folks for all your time and attention. I appreciate it, and I hope that I will get to meet some of you soon to go over some of these things in person and drill down on your specific situation so that we can make sure we've got an estate plan set up to meet your needs. Thank you very much, folks.